Welcome back to our session on how laws around sourcing and responsibility and current cases in the US Supreme Court affect jewelers. I hope you've been taking time between sessions to get into the networking area and meet your fellow conference participants. Right now, I'm very excited to introduce this panel. I have with me today Wyatt Julien, who's staff attorney for Earthrights International, Jennifer Fendrick, who's Senior International Relations Officer, Office of Child Labor and Forced Labor at the U.S. Department of Labor, and Julianne Kippen, Associate Director, Children's Rights Division of Human Rights Watch. Thank you all for joining us and for taking time to prepare for this panel. We're so excited to have you here today. Our goal for the panel today is twofold. The first is to create awareness around laws, cases, regulations, and the reach and extent that the jewelry industry shares culpability for issues that are coming to the courts, could come to the courts, or may be subjected to increased regulation, or we may wish would be subjected to increased regulation. The second goal of this panel is to explore the role of law in making supply chains more responsible, and its benefits and drawbacks, because there are both, as compared to self-regulation, international agreements, and regulations, because these are four different ways of influencing supply chain behavior. So that's the goal for this panel. So with that, I'm going to turn it over to Wyatt first. Each of our speakers is going to share with you for about 5 minutes just what they're doing in their sector of responsibility, and then we'll have a more broad conversation. So Wyatt? Oh, your mic is off, it looks like.
Hi everybody. Yeah, I'm just gonna share a quick presentation here, if I can. Maybe.
Has your share button disappeared from the bottom of the panel, or can you find it?
I can find it. I'm just trying to hit it up. Okay, can you see it?
It's coming up now. There it is. You're good.
Okay, great. Sorry about this. So my name is Wyatt Julien. I'm a staff attorney at Earthrights International. Just to give you some background, what we do is we work on corporate accountability, climate justice, and protecting human rights defenders. And we do that through litigation, through training, capacity building with communities, and through policy advocacy. We've taken different types of industry actors to court in the United States for human rights abuses, corporate abuse, including Newmont Mining on behalf of Maxima Cunha Atalaya and her family. We also are not limited to the mineral sector. Took Occidental Petroleum to court for pollution in the Amazon. Had some degree of success there in the U.S. courts, and currently litigating a case against Chiquita Banana for financing paramilitary death squads in the banana growing regions of Colombia. So based on, we don't have expertise per se in the laws that are governing specifically mineral resource extraction, but I'd like to speak more from, our experience litigating transnational human rights litigation, corporate accountability cases. And I just want to make a few quick points at the beginning today here. First, corporate abuse is widespread in U.S. investments in supply chains. It can involve, pollution, land grabbing, forced evictions, modern day slavery, which I'm sure my colleagues will touch on more, labor rights, attacks against defenders, and it affects both big companies and small companies, particularly in the gold mining industry, where small scale gold mining is a huge problem in the southern Peruvian Amazon, where we work, among other places. I also wanted to highlight something that goes under the radar in the mining sector, just for the audience, and that there's frequently agreements between mining companies and public security forces, where the mining companies contract the public security forces to provide private security for the mines. And that's deeply problematic because it subordinates a public force that should be guaranteeing fundamental rights of the public to corporate interests, and it also has a detrimental impact on the right to protest and the freedom of expression. Just one big takeaway from our work and kind of a recent analysis we did in the white paper on corporate accountability at Earthrights is that the voluntary initiatives are not enough. They're not a substitute for being held legally accountable in a court of law. They're fine, and the UN guiding principles on business and human rights have led to some progress, but it's clear that after 10 years, it's been an insufficient measure, and what we need is clear laws that provide effective remedies to victims, and that also create effective deterrence for corporate abuse. So when companies violate human rights, they face consequences. That said, it is possible to hold companies accountable in U.S. courts in civil lawsuits for abuses that they commit outside the country in the name of on behalf of communities that have suffered from those actions. Excuse me. You can bring common law tort claims. Previously, the Alien Tort Statute of federal human rights law provided a vehicle for bringing human rights cases against U.S. companies. It's been severely narrowed and restricted by the Supreme Court in the last decade, including in the last October term of the Supreme Court in the Nestle case. And then there's other federal human rights statutes that speak to specific types of human rights violations, but are pretty narrow in their scope. And then in all these, there's frequently barriers to suit. The doctrine of personal jurisdiction is limiting, as well as a doctrine called forum nonconvenience, which basically allows a company to argue that it's not convenient to litigate in their home forum, and the case should be brought outside the country, usually in the place where the abuse occurred, but where sometimes the institutions are weak, or there's corruption, or there's threats to the plaintiffs if they're going to bring the case. So ultimately, we need strong legislation. We need mandatory human rights due diligence and laws that create the ability for victims to bring lawsuits and hold companies accountable if people want to have confidence in the supply chains and investments that produce the products that they buy. I'll leave it there. Hopefully that wasn't too long, and pass it on to the other panelists. Thank you.
That was perfect. Thank you, Wyatt. So I'm really hoping that as an audience, we're starting to gain some vocabulary around these things, because we can't be effective in helping to enact change if we don't have the vocabulary. So that was perfect. Okay, next I'd like to ask Jennifer to share some information with us.
Thank you, Andrea. My name again is Jennifer Fendrick, and I work for the Department of Labor, the Office of Child Labor, Forced Labor, and Human Trafficking. I want to give a quick plug to my colleague, Caleb Owen, who will be speaking in much more detail on our mandate, including efforts to assess the extent to which governments are adhering to internationally recognized standards on child labor. He'll be speaking at 2 or 3 p.m. Eastern. But what I want to talk about briefly today is a little bit on the role and limitations of jurisprudence in stemming labor abuses in jewelry supply chains, and also a little bit about how children in armed conflict continue to play an outsized role in some of these supply chains. So I want to begin just by talking a little bit about gold. So illicit financial flows are by definition difficult to quantify, but the UN has estimated that about $40 billion of illicit financial flows from sub-Saharan Africa are derived from extractive commodities. And about 77% of this is in gold. So that's about $30 billion. And we know about a ton of illicit gold leaves the DRC every year. It's very easy to smuggle. It's hard to trace. You can melt it in your backyard. And much of this gold ends up in a gold souk in Dubai, where it's effectively laundered and then it enters the global supply chain. And this gold finances warring militias throughout sub-Saharan Africa. And children are recruited by many of the same non-state armed groups who control gold and diamond mines throughout the continent, and in fact, throughout much of the world, including in Latin America, as Wyatt has mentioned. And these revenues also fund corrupt state security forces and ultimately contribute to insecurity. So as an example, we've seen evidence that there is a state element of a major country in sub-Saharan Africa that arms a non-state armed group that forcibly recruits children and uses forced recruitment to sustain their operations. But under this arrangement, this group has been able to establish control of major lucrative gold mining sites where they're subjecting children and adults to forced labor. And the group has actually emerged as the dominant non-state armed group in this region. And we've seen evidence of child soldier recruitment and forced labor converging around diamond and gold and other precious gemstone mines around the world, including in Mali, Colombia, Venezuela, most recently in Mozambique as well. And so diamonds, despite the Kimberley process, do remain problematic. But I want to just quickly note that the Kimberley process, because it has provided a kind of unified certification framework within the narrow confines of its mandate, has been, I say, a qualified success. So in the absence of a kind of similarly unified international agreement around responsible sourcing for other minerals and precious gemstones, we continue to see really fragmentation in due diligence schemes, including around gold and other precious minerals. So in gold, for instance, there are as many as 45 different blockchain initiatives. Now I just quickly, if there's time, I just want to just touch on a U.S. conflict mineral provision, DoddFrank. This was passed in 2010. This is part of the Dodd-Frank Wall Street Reform and Consumer Protection Act. The conflict mineral provision, which is Dodd-Frank 1502, requires companies to disclose to the Securities and Exchange Act whether certain conflict minerals originated in the DRC or an adjoining country. Part of this law was actually invalidated by the Court of Appeals in 2016. It was found to violate the First Amendment. This was part where the companies were required to disclose that their products have not been found to be DRC conflict-free unless they've been explicitly found to be conflict-free. As Wyatt alluded to, there are a couple of other cases that have been wending their way through the courts, including the cocoa case, which is Nestle Cargill v. Doe, which the Supreme Court ruled 8-1, that the companies lacked enough of a U.S. connection to go forward under this very old statute, Alien Torts. Cobalt, the similar lawsuit was actually dismissed last week by a district court against tech companies that alleged complicity in child labor in the DRC cobalt mines. They found that there was not enough of a causal relationship between the firm's conduct and the miners' injuries. So does this mean companies are off the hook? Well, no, because we're seeing increasing pressure from investors to adhere to ESG standards. There's likewise been a real uptick in litigation around these disclosures, which we can talk about more in the discussion. And finally, the executive branch, for which I work, has a really important role to play. And a couple of years ago, Congress expanded the Trafficking Victims Persons Reauthorization Act, which mandates, among other things, that the Department of Labor, publishes an update to a list of goods made with child labor or forced labor in their production. And under this expanded mandate, we are now required to investigate the provenance of goods made with inputs from child or forced labor, which means we are now currently ramping up our capacity to track and investigate materials and goods as they enter and move along the supply chain. Looking forward to this discussion, and I will pass it back to you, Andrea. Thanks.
All right, thank you. So a mixed bag. Our courts seem to be getting a little less lenient, but we've got some regulation in place that's giving at least funding for you guys to look into some of these things as well. Okay, Julianne, over to you.
Thank you. I work at Human Rights Watch. We are an international human rights NGO, and the main thing we do is research to investigate human rights violations, and including human rights violations in the context of mining and more generally business responsibility. So we've conducted research on many different kinds of mining operations around the world, and advocacy with governments, with companies themselves, and also other actors. And in my own work, I have done primarily, or sort of started out with looking at child labor in small-scale gold mining, for example, documenting that in Mali, Ghana, Tanzania, and the Philippines, but then kind of moved on to broader questions around company responsibility, and have been giving a lot of attention to the responsibility of jewelry companies in particular, where we published 2 large reports ranking brands, jewelry brands, once in 2018 and once in 2020 for their basically their sourcing practices and their human rights due diligence or not. Perhaps to briefly just also, give a very quick snapshot of some of the issues we're dealing with. And some of these human rights issues were, of course, mentioned already, but of course, mining often contributes to violations of indigenous people's rights, land rights, and environmental rights. And one example for that is gold mining in the Amazon in Brazil, where indigenous people have faced land invasions, threats, violence, and environmental harm. And just a few months ago, there were attacks, for example, by criminal groups on indigenous people's leaders, and that really put them under threat. That's just one example, and these groups were linked to basically groups supporting mining. Another example is labor rights abuses, a whole range, including, of course, child labor, but also lack of health and safety in mining more generally, also in manufacturing, mining accidents. I mean, we've documented numerous deadly mining accidents. And for example, the rise of child labor in small-scale mining in the context of the pandemic, where in the last year and a half or so, the numbers have really gone up in several African countries, for example, in small-scale mining. And a place where I've done quite a bit of research is Ghana, and the typical thing would be that children use mercury to wash gold, unaware of or sort of withdraw the gold from the ore, unaware of the health consequences, do crushing work, carrying work, breathe in dust from processing when they use machines, and obviously also forego an education often that way. A third set of issues related to armed conflict and violence more generally, where, of course, not only armed groups, but also state forces, private security personnel, and so on are responsible. An example for that is abuses against protesters as well as small-scale miners in Zimbabwe in the Maranga diamond fields, where, for example, a private security company linked to a government-owned company has actually committed terrible violence against local miners. That's just sort of as a backdrop. And against that backdrop, we have started to work much more on the issue of the question, first of all, what do companies do that are in the supply chain to avoid and prevent that they're contributing to abuses? And then more specifically started to look at the importance of mandatory rules. So in other words, a bit like actually Wyatt pointed out earlier, our work has also really brought us to the conclusion that what's needed is mandatory human rights due diligence. It needs laws and not just voluntary standards. There is, of course, a trend right now, particularly in Europe, but to some extent in other industrial-led countries too, that actually means that more and more countries are enacting laws that way. So examples for that are the DoddFrank Act was already mentioned, but examples for that are also the UK and Australia with relatively weak laws, but nevertheless laws on modern slavery. France with quite a strong law and a really broad law. So not specific to any particular sector. Germany just enacted a law in June this year. It has some weaknesses, which I'm happy to expand upon, but nevertheless it did. And Norway also just enacted a law. And of course, there is the EU conflict minerals regulation that entered into force in January this year. In addition, there are a number of other legal initiatives underway brought by different parliaments, for example, in Austria, Belgium, Finland, the Netherlands, Switzerland, and Canada, and of course, very importantly, at the European Union. And I'm sure a few of you at least are aware that at the European Union level now, there is this plan, and it started with about a year and a half ago with the Justice Commissioner, Reinders, committing or pledging that there would be a law on human rights due diligence and environmental due diligence as well. So a law that would include both human rights and environmental aspects. And in March this year, the European Parliament adopted what's called a legislative initiative report. So basically a proposal for the law with quite a lot of detail. And at this point now, the Commission is working on a proposal. There is a lot of different controversy and tension and kind of lobbying as well going on. The proposal is expected in December. It has been delayed, so we'll see when exactly it comes out. But that's certainly a very important sort of piece of legislation that's potentially on the horizon. What that really means is that overall, I think it's fair to say that the era of voluntary standards or pure voluntary business conduct has ended. There is definitely a recognition by numerous governments now that new legally enforceable regulations are needed or rules are needed, building on the UN Guiding Principles framework of the United Nations. In about 10 years ago, the United Nations adopted this framework and basically the concept of human rights due diligence. So the responsibility, spelling out the responsibility of companies to ensure that they do not contribute to abuses in their supply chains through several steps, notably assessing human rights risks, taking steps to mitigate them, address them, and prevent them, then getting audited for these efforts and being transparent about it. So disclosing information about steps taken in a nutshell. And these laws are broadly speaking built on that, although there's a lot of difference as well between the different sort of national variations. When we say voluntary initiatives, we largely mean industry-driven standards. And as Jennifer just pointed out, there's many, many standards around. Some of them are quite strong and have really the potential to, for example, define best practice and help some companies really move forward, but that they cannot replace legislation. That's very clear from our perspective. Similarly, the Kimberley process, when we talk about that, and perhaps just to clarify, that is not an industry standard. That is a government certification scheme of basically export and import movement. And it has a sort of voluntary standard attached to it. I'm happy to explain. It's very weak. So having said all of that, I want to perhaps just quickly end on saying why we think this is so important and what in particular we think should be the elements of strong human rights due diligence. Because just having a law that says human rights due diligence in its name doesn't necessarily mean it's a good law. It's important because, first of all, this means that governments recognize that companies have a human rights responsibility and they actually have an obligation to act, not just in their own borders and in their own operations, but throughout their supply chains, including across borders. Secondly, what's quite clear to us, many companies will only act when there's a law. There are some companies that are sort of champions and really move ahead before there's a law in place, but many others don't. And that's why the laws are needed. They are also needed then to protect these kind of more, these protagonists and these champions, because otherwise it can become kind of a disadvantage to spend a lot of money on, for example, human rights due diligence measures when others do not invest in them. But this way, the playing field is leveled. Ultimately, it's a measure of accountability and of transparency, accountability to the public in the country or the region where the laws are passed, but also accountability to the consumer, to the affected communities, to the wider public. And of course, as we've heard from Wyatt a moment ago, companies can and should be held liable for basically wrong conduct when there are particular abuses taking place. And I want to just mention one case that's a few months ago where a diamond company in the UK, Petra Diamond, they were not, they didn't lose the case, but they agreed to settle because of a suit brought around violence committed in the Williamson diamond mine in Tanzania against 71 people, and they ultimately agreed to pay something like $5 million in compensation. And these kinds of things are important to show that companies, well, in this case, can't really be held accountable, but can actually be obliged to take some actions to, in this case, compensate at least. The key elements, very quickly, I'll end on that. Human rights due diligence needs to span the whole supply chain of a company. It needs to apply to all companies and all sectors. It needs to cover both the broad range of human rights issues. So not just, for example, only be limited to child labor or modern slavery. From our perspective, we need a broad approach on human rights, but also the environment, including climate change. It has to have strong disclosure and transparency provisions to really ensure that companies report publicly about the risks they've identified, the non-compliances they've identified, the steps they've taken to address those, and also the supply chain in itself, like what does their supply chain actually look like. And lastly, it needs to have both an enforcement mechanism, really a sort of competent authority to enforce it, as well as the possibility of liability for human rights and environmental harms that a company has been causing or contributing to. And I'm probably over my 5 minutes, so I'm going to stop there.
Very interesting and helpful, though, so don't worry about it. This leads me to, thank you, Julianne, that was really good. I have so many questions after listening to all three of you. Like, one question would be for specifically for Jennifer, because you were talking about your increased responsibility to report on child labor. Is there an enforcement element that's attached to that reporting, or is it just informational in nature at this point?
Sorry, it's muted. So at this point, the mandate is informational in nature. However, we are looking at efforts to sort of tie some of our research into USG-wide, that U.S. government-wide efforts to sanction some of the actors, some of the actors, the bad actors, that we do end up identifying in the supply chain. And so we are working on a sort of whole of government effort with our colleagues in DHS and Treasury specifically to try to sort of attach an enforcement angle to the work that we're doing. But at this point, the list of goods that we produce every 2 years, including the list that we will be producing this year under this expanded mandate, is more informational in nature.
And then I'm also curious, and I'm curious globally, and I think Julianne just gave us sort of a good view of the more European UK element of this, but is there a higher, like when we want to take a company to task for violating a human rights or some regulation, is the burden higher for us to prove that the company was wrong than it would be in a different sort of legal case? It seems to me that the companies have a lot of different ways to skirt responsibility in a courtroom setting, either by saying it has to be tried in another country where they'll have a lot of support from state-sponsored actors to, cover up for them, or whether it just seems there are ways to skirt it. So my question is it really hard to prove that a company has violated human rights, or is it not hard to prove, it's just hard to get people to value that information?
I would say that this sort of the most sort of recent spate of cases, including the cocoa case and the cobalt case, both of which have been dismissed, would indicate that the burden of proof for the plaintiffs is quite high, and that in both cases the courts found that they were not able to provide a sufficient sort of causal link between the children who were subjected to forced labor in the cocoa fields or in cobalt mines were linked to these companies who were the defendants in both of these cases, which is not to say that, I'm speaking on my own behalf, not the US government's behalf, that these companies should not be held to account. But as both Julianne and Wyatt have mentioned, we need much stronger legal frameworks, including, I think, a more kind of unified international effort to address many of these issues. And some of the provisions that are currently on the books in the United States, including DoddFrank 1502, have not been really adequately enforced by the SEC, and there really are limits to voluntary compliance. And we've seen in cobalt, we've seen and in gold, and in many other sectors, just a multiplicity of efforts that are very difficult from our end, from the U.S. government's end, to trace. And in many cases, there are traceability schemes that are competing with each other. There are third-party auditors who, in some cases, may be beholden to the companies that they're working for. So the fragmentation is a big issue. And again, I think that there is a role for voluntary compliance, and we are seeing that in recent cases, including against Chiquita Banana, for falsely claiming to uphold certain ESG standards, as I think Coca-Cola, Walmart, a number of other companies have been subjected to similar litigation for making claims around ESG.
You've referred to ESG a couple of times now. Could you clarify for our audience what that is?
Yeah, those are our voluntary environmental, social, and governance standards that companies are increasingly under pressure from investors to comply with, over and above what the law dictates.
Thank you. There's a question from the audience. Abigail Sibanda is saying that the issue of compensation would be difficult to take off in Africa, where companies don't take the initiative to acknowledge abuses and rights violations. And she's asking, what can we do to ensure that large-scale mining operators commit to these responsibilities? How can we influence it? Anyone have?
I can maybe take that, but I just want to also piggyback on what Jennifer was saying and respond to that question about the burden, how hard it is to hold companies accountable. Corporations enjoy a variety of benefits that natural persons don't in courts of law. The Supreme Court has ruled, in some personal jurisdiction cases where the court has jurisdiction over a company, has made it harder, right, than it would be to establish jurisdiction over just a real live person. Usually, you can have jurisdiction over a person if you find them in the forum, if they're physically present in the forum. But now, essentially, to have general jurisdiction over a company, it has to be the place of incorporation, or where they're headquartered, where they're at home. So that's one benefit they enjoy. Also, just the limited liability. The corporate structures are very complex, and so it makes it difficult to. There's lots of doctrines about limited liability based on a corporate entity and shielding shareholders from a subsidiary's actions, and so that structure itself makes it difficult to connect the dots from the corporate human rights abuse to the parent company, potentially in the United States. And so without clear legislation, companies take advantage of this kind of ambiguity and complexity to deflect from general allegations of human rights abuses rather than to address them. Not always, but that's one consequence. And so just to answer your question about how to make companies take seriously their obligations, they will when it's in their interest to do so, and it'll be in their interest to do so when they face consequences for not doing so. And so that means we need strong accountability that with enforcement teeth. And when they commit harm, they need to be held accountable. And if that's the case, then I think you'll see more improvement in the supply chains than through voluntary initiatives.
So increasing consumer awareness and taking seriously our responsibility, not just to speak with our dollars toward these corporations that are operating mines, for instance, at the beginnings of our supply chains, but also having stronger legislative demands as industry members. Both are important. That's what I'm getting out of that. Did I get that right?
Yeah, I think it's being conscious as industry, as economic actors, and our economic choices. It's promoting legislation that contributes to corporate accountability and responsibility. Yeah, those two things.
We'll be seeing an example in tomorrow's water panel about how at first people weren't familiar with the issue of mercury, particularly in the Amazon will be the angle we're discussing tomorrow. Then people became familiar with the issue, and opacity was the main culprit. Nobody could see the problem, so we couldn't act on the problem. Then when opacity was stripped and we had visibility to the mercury problems in the Amazon, right down to maps, well, then corruption became the bigger concern. So corruption's always a concern, but corruption then was still present, I guess. Are we seeing movement on child labor in particular, and forced labor? Like, is there an improvement in the world? Are we seeing it more, but we're still dealing with corruption, or is it just a problem that moves around like golfers in a golf course?
I can say that we have absolutely seen an uptick in child labor in sub-Saharan Africa. Most of the rest of the world did see a decline, but in the wake of COVID-19 and the school closures, we have seen a pretty marked increase in child labor. And I would add that for instance, in the Central African Republic, we saw a pretty significant increase in the number of children. I think a 50% increase in the number of children under 15 who are working in diamond mines in the Central African Republic. We don't necessarily have enough data on other countries to give any kind of specific numbers on this, but it is a very pretty significant issue in sub-Saharan Africa, where 1 in 4 children are in some form of child labor right now.
And does that statistic span the range from large-scale mines to artisanal mines where it may be a family mining, or is that mostly looking at the larger scale mines?
I would say more in artisanal mining, most of the uptick in child labor, to the extent that we are able to document this. It's very difficult to get to kind of quantify some of these numbers. For instance, in the Kivus and the DRC. To get a really good estimate on the number of children working in those mines, because they're in such insecure areas. But most of the increase, I think, has been associated with children working in artisanal mines, as well as in other sectors like agriculture.
And Julia,
also come in there as well. Yeah, thank you. So first of all, on child labor, yes, I mean, that's what we've documented as well, that in numerous cases, and we know this from some other organizations as well, they've documented how child labor has actually been on the increase since the beginning of COVID-19, and that has been a reversal of the trend, because overall globally child labor numbers were going down actually since 2000 roughly, still too high, but they were actually going down. We published a report in May this year that I'm just going to put into the chat that is not specific to gold. It is just about the increase of child labor in both Uganda, Ghana, and Nepal, but it has examples from gold mining, small-scale gold mining, and also stone quarries in both Uganda and Ghana. So that's perhaps just on that particular issue. Secondly, I just wanted to quickly get back a little bit to the issue of kind of liability and having companies in court. Indeed, I think there are many examples that show how companies try to evade and how challenging it is to actually bring these cases. At the same time, perhaps we have to remember that at least in Europe, some of the human rights due diligence legislation is very new. So in France, it's from 2017. There have been a few cases brought, and they were not particularly successful. They kind of failed on formal grounds. But there's, I think at least one is also ongoing. And then in Germany, of course, the law isn't enforced yet. It was adopted in June and will enter into force in 2023. However, this law has no liability clause. I mean, we and a whole coalition of organizations in Germany were strongly advocating for a liability regime, but that was rejected. And so the law, that's one of the big weaknesses of this law. It has a relatively strong enforcement mechanism. Let's see if it really becomes that kind of body, but it doesn't allow for justice. Then the last point I wanted to say on that is that in the European Union, this is really one of the big sticking points. And of course, as just comes out of our discussion right now, how important it is to ensure that when companies do not fulfill their obligations or their responsibilities, they actually have to be held accountable and they have to go to court over that. Of course, the linkage has to be created. It's not like just because a company has sourced from somewhere and then there's a mining accident, they're immediately going to court. I mean, it's much more complex, much more complex than that. But when there is proof that the company did not conduct the human rights due diligence necessary and so on and so forth, then it should definitely be possible. And at the moment, there's a lot of pushback from lobby groups in Europe against that, industry lobby groups against that kind of liability, where many of the civil society groups, of course, are pushing for that. And Reinders has, in principle, the Justice Commissioner of the European Commission, last year has actually announced that the proposal would include liability, but I think that is under discussion now. It's not certain anymore.
We often see laws that have, a lack of a liability component. It may have enforcement, even though it's weak, but lack of liability. Is it a matter of is it better to just at least have the law in place and then work for the liability component, or are these toothless laws that are passed to appease people without creating any real responsibility?
From our perspective, I mean, you have to look at the particular case, and there could be laws that are so weak that it doesn't make sense to support them. In Germany, we felt that ultimately the stop law was still sort of a small step in the right direction, in the sense that it changed the paradigm and established the simple recognition that companies do have an obligation to conduct human rights due diligence. And if the law was interpreted in a robust way and also implemented and enforced in a robust way with a strong, competent authority, it could still bring change.
I don't know, Wyatt or Jennifer, if you wanted to add anything to that thought. I had another question, but I don't want to run along if you were waiting to click your mic. No. All right. So Susan Erickson points out in the chat, she says, I think we might talk of the end of the jewelry supply chain, not only of consumers, but of investors and the changes that are taking place in corporations from shareholders. And then Sean Clinton adds to that De Beers shareholders are challenging claims that their diamonds are conflict-free due to the links to Israeli war crimes. So that's a good correction for me, to not just speak in terms of being the money end of the supply chain as users of the materials, but also applying pressure to the investors. But it's difficult to figure out who the investors are to apply pressure to them as well, isn't it?
Yeah, hi. I would agree with that assessment, and I think I would add that this kind of speaks to some of the limitations under both DoddFrank and then the Clean Diamond Trade Act, which was passed in 2003 as part of the Kimberley process. This was passed in the United States as part of the Kimberley process, and the Kimberley process, again, it's an international agreement that prohibits the trade in kind of rough conflict diamonds, but it's very narrow and it does not include a lot of labor issues. doesn't include human rights abuses, violence against minors, money laundering, or other financial crimes. So it's very limited in scope. Likewise, DoddFrank is extremely limited in scope. And again, DoddFrank applies to conflict minerals that come from the DRC or the surrounding region. And so gold, 3TG, which is gold, tin, tantalum, and tungsten. And again, as I mentioned, part of that law was invalidated by a court of appeals, and the parts of the law that remain in effect are sort of weakly enforced. So the SEC has said companies don't need to file due diligence reports unless you label your product DRC conflict free, and then you do have to perform an audit. But so what's happened is that some states have decided to pass, in the United States, have decided to pass their own kind of more stringent legislation around so-called conflict minerals and diamonds. But again, because of the piecemeal nature of these efforts, it's very hard from our perspective in the government to kind of track the effectiveness of a lot of these lines of effort.
And I think that points out something important for us as jewelry industry members in the room need to think about. It's easy to hear about a case involving cobalt or rare earth metals or even base metals and think, well, that's not us. But it is us, because those are big companies with a lot of money. They can establish precedents in the court that then can be applied to the people going after the metals that we use. So I think it's really important that we pay attention to mining legislation overall. Did I get that right? Did anyone want to challenge that idea or add to it?
Yeah, I would absolutely agree with that, and also just note some of the sort of physical limitations of tracking. Some commodities like gold, for instance, which it's very difficult to establish kind of chain of custody. As I referenced earlier, like 95% of the artisanal and small scale gold that is exported from Africa ends up in the UAE, which routinely reports a much higher value of imports than exports, than the African states export, which is a huge red flag for illicit activity. And there are 11 gold refiners in the UAE. Only 2 of these, I think, have passed third-party audits. So there are huge AML/CTF shortcomings in the UAE, and that's a major kind of choke point that we're trying to look at in the U.S. government specifically.
And Amber Valles from SCS Global chimed in on that and said that she thinks holding investors accountable really lies on the responsibility of companies and businesses and boils down to conducting effective enhanced due diligence, speaking to what Julianne has mentioned several times, which should include know your counterparty, or the acronym is KYC, awareness and checks, so we can apply pressure there as well.
Can I perhaps just add something to this? I mean, we've been obviously mostly talking about laws, and the question of what an individual jeweler can do is slightly different. But in addition to supporting strong laws, of course, there are specific steps that companies can take, and we have looked at this in our jewelry work in 2018 and 2020. And in a way, the really interesting finding was that despite the many challenges of mapping supply chains, assessing risks, and so on, there was some jewelry companies that did significantly better than others. I mean, that was perhaps the most interesting finding, that there were actually examples for positive steps that companies can take. So there are companies that have actually mapped their supply chain. There are companies that are sourcing from small-scale mines that are, for example, fair mine certified, and that where the risk of abuse is at least less high, and where there's much stronger, possibility of really supporting a professional mine where people are actually working under rights respecting conditions. There are jewelers who have, for example, disclosed violations or non-compliances that they found in their own audits. Not as much detail as we'd like, but still it's happening. There are miners as well who are doing that, for example, as part of the IRMA standard, the Initiative for Responsible Mining Assurance now. And they actually publish really interesting, really, really detailed information, including on serious problems that they found, which is unusual for the industry. So the interesting thing is that there are some companies that are actually kind of at least going in the right direction and showing some of this is possible even without laws. This is not to say that there shouldn't be laws. You've heard me before. Ultimately, in order to bring the whole industry along, laws are absolutely necessary. But it's positive to see that change can happen. It's not impossible. Despite these pretty real challenges, some companies do actually manage to overcome them.
Yeah, I really want to agree with what Juliana just said. I think we do need to applaud. There are companies who are taking steps to voluntarily conduct due diligence in their supply chains and to invest in particularly in upstream due diligence efforts, in the DRC and other countries that are considered high risk. And voluntary industry standards really do have an important role to play in this respect. But just again, to reiterate the fact that there are limits to self-regulation, and the fact that the SEC exists is a testament to these limits. It was created, of course, after the market crashed in the United States in 1929. Passage of DoddFrank also, that was passed after the 2008 crash. But I definitely agree that there is a role for voluntary standards. One of the major issues that we do have is even when companies are trying to do the right thing, that there are so many competing traceability schemes in various sectors, mineral sectors in 3TG, cobalt, copper, diamonds, et cetera, that it's just really difficult to trace the minerals from mine to smelter and further downstream, which is what we're trying to do right now at U.S. Department of Labor.
Well, it's a huge barrier right now in the industry because of the number of different traceability schemes and people advocating for their own scheme over another scheme and the difficulty of implementing various technologies in various markets. At the moment, it's more of a mess than a help. I mean, it is some help, but we need to get to some kind of standardized traceability scheme in the mineral markets if we're going to actually have clarity.
I just want to jump in and just emphasize that I think ultimately when these standards of conduct and due diligence become obligatory, I think it'll help the mineral industry as a whole, right? Because it'll create a race to the top. It'll create a more stable investment climate globally. There's empirical studies that link respect for human rights to stable investment climates. And so you have, these, it's not something that, we're not trying to, I think it's ultimately in companies' best, in their self-interest to support these types of standards. And I mean, if you look at, there's actually an interesting thing, if folks are interested, there's an amicus brief that was filed in the Nestle case by Joseph Stiglitz, who was former head of the World Bank, renowned economist. And he just lays out all the economic arguments for efficiency and for how this is going to promote business. So I'd encourage people to look at that as well.
Absolutely. I had a question, and I can't wrap my lips around it. So I'll ask a different question, which I also had earlier. Is there any more? There's been effort to sort of take the teeth out of DoddFrank several times since it was implemented. Are there any open efforts right now to again weaken the act that you guys know of?
I'm not aware right now of any efforts to weaken DoddFrank, which again was not, I would say, robustly enforced over the last 4 years. But I think there's some indication that the SEC is moving to enhance its enforcement efforts potentially. Although I don't work for the SEC, so I can't speak on their behalf. But I think that there are some indicators that the parts of the SEC that haven't been invalidated by the courts may be more robustly enforced than they were from 2016 to 2020.
So that would be good news. All right, we're getting down to our last 5 minutes. If any of you have further questions for this panel, now's the time to drop them in the conversations or the Q&A, because it's such a cool panel to be able to ask questions of. One question that we still have is, do members of the panel agree that the deliberately narrow Kimberley process definition is actually a shield for industry to hide behind? So slightly loaded question, but fair. So
happy to jump in on that one. I mean, we are one of the groups that have been calling for a wider definition. And of course, there is the Kimberley Civil Society Coalition that we're not part of, that consists of numerous organizations, particularly African human rights organizations or NGOs in different producing countries, and that really work with affected communities around the impacts of diamond mining on local communities. In fact, the last panel before this one, of course, dealt with exactly that issue. And from our perspective, definitely that is a huge problem, that there is a scheme that has been set up by governments to only rule out that rebel groups, armed groups, benefit from diamond trade, and not state security forces, government forces, armies, or groups like that. And from our perspective, that's a huge problem. I gave the example of the Zimbabwe human rights violations, violence in the Maranga diamond fields earlier. And the problem with that is that the diamonds, in part, or one of the problems is pointing out the problems of the Kimberley process. It's the diamonds from Maranga, where miners get seriously tortured, arrested, and so on, still are getting the Kimberley process certification and are still on the regular, legitimate market. And so that points to the problem.
Yeah, and I would add that another sort of prominent example of the shortcomings of the Kimberley process, again, is the diamond mines in the Central African Republic, who many of which are controlled by the Yevgeny Prigozhin-owned Russian PMC Wagner, and the fact that the number of villagers have been executed in and around gold and diamond deposits in the Central African Republic as recently as a few months ago, as was reported in the 2021 UN panel of experts. And of course, Russia is right now the chair of the Kimberley process, so that there are quite a few issues around the Kimberley process, not least of which is the fact that it's arguably overly narrow in scope. But yeah.
Susan Crow is asking if you see gold and diamonds as the new cocaine, and is there any sign of organized crime being involved in putting pressure on the corporations involved?
I would certainly, I think I would agree with that assessment, that characterization of gold and diamonds as potentially the new cocaine. We've seen quite a bit of evidence that gold and to a lesser extent diamonds are funding a number of terrorist organizations and criminal syndicates and non-state armed groups in sub-Saharan Africa, because of the difficulty around tracing gold, and again, the fact that most of this gold ends up in a souk in Dubai, which has almost no oversight. It means that yes, I think I can't speak to specific what percentage of the illicit gold that leaves Africa specifically funding these sort of illicit activities, but it is extremely problematic, and the U.S. government is very concerned with these developments.
Mark Hanna has a question on Dodd-Frank, and Mark Hanna to me has the distinction of having been a person working within the Berkshire Hathaway organization that was fighting to not weaken Dodd-Frank. So, and his question is, what do you think the current status is of Dodd-Frank and required reporting?
I think again that we've seen, I would say, a kind of a weakening in a lot of the reporting requirements for Dodd-Frank over the last 4 years, and there was really, the SEC did not enforce a lot of those requirements. In fact, I don't think they enforced them at all. I think that there's some indication that of a reversal in this trend over the next few months, but because I don't work for the SEC, I certainly don't want to speak on their behalf. But I do also know separately that the SEC has indicated that it will potentially be enforcing some of the kind of ESG disclosure standards. So companies who choose to sort of voluntarily disclose their adherence to the environmental, social, and governance standards, and who are subject to litigation may be subject to also to increased reporting standards from the SEC in the coming months.
And Susan Erickson has a very interesting question. She wants to know how the DoddFrank law as we know it, and which is over a decade old, compares to the recent laws that Julianne was speaking to in Europe.
I can only say I don't know too much about the European laws, other than that they are not, unlike DoddFrank, which is very geographically specific and only deals with conflict minerals from the DRC and the surrounding areas. My understanding is that the European law is much broader in scope, at least geographically, which I think suggests that it might be a little bit more effective than 1502. I'll let Julianne expand on that.
I'm sorry, I kind of missed I was answering to somebody on the chat. So can you repeat the question, please?
Yes, the question was how the DoddFrank law compares to some of the recent laws that you were discussing in Europe.
Right. Yeah, okay. In very brief, there's two different kinds of laws, of course, in Europe. And I've been mostly speaking so far about the proposed law. It's not yet there. That is really broad on human rights due diligence for all sectors. But there is the existing law that is a little bit comparable. That's the EU conflict minerals regulation. The difference is that it is not focused on a particular part of the world, as opposed to DoddFrank, which is about Congo and its neighbors. It has a due diligence requirement, which I think is slightly broader, but there are definitely some similarities as well. I mean, to be honest, I haven't done the sort of detailed comparison and legal analysis. There are differences as well, but they are both laws that are for specific minerals, gold and 3Ts. If I'm right about the DoddFrank was that, right? So anyway, that's the case for the European minerals regulation. And in the case of Europe, it's not for manufactured goods, it's only for raw materials and the import of raw materials. And they, in that sense, perhaps have some similarities and then narrow focus on these particular materials, I think.
All right, and with that, we are out of time. Mark Hanna posed one other question, which I have posted into the broad chat for the whole conference. I would invite all of you to go to the networking tables and discuss this question. And the question is, do you believe that climate issues will become the new conflict minerals in future best practices reporting? I think this is a really valuable thing for all of us to be discussing as a group. So thank you, Julianne, Wyatt, and Jennifer, for your time and sharing your incredible knowledge with us. This was really informative. So we really appreciate you.
Thank you.
Thank you.
Pleasure. Take care, everybody.